Well, hello there, ladies and gents. It is great to see everybody again, and welcome back to Closing Arguments. Ryan Ruff here, your moderator, but as always, I've got my right-hand man in Jack Razumich of Razumich Associates joining me. Look, we've got a great conversation teed up for everybody today. I know it's been a few months since we dropped an episode. That's because Jack and his team, plain and simple, have been working their tails off over at Razumich Associates, a handful of jury trials, things popping up, coming back off the calendar, popping up, coming back off the calendar. It's been a bit of ping pong for the team over there. But we are so excited to have everybody back today. And if you're a frequent or a regular listener of this program, you know that we're constantly re-examining and looking to the future just surrounding the greater concept of jury trials. We've watched massive changes since back in the 60s, 70s, 80s, even in recent history in the last few weeks, let alone months. We're seeing the concept of jury trials really change, how people approach them, how people want to see the fallout of them on the backside. Are they even worth it? So as we sat down and thought about today's conversation, it really does feel like trials these days can almost feel like a gamble where the stakes are the highest they could ever be because it's your life that is on the table. So that's why our episode today is entitled Why Trials Can Feel Like Gambling with Your Life. So we're going to be diving into a few things today. We're going to talk about, how just this idea of going to trial, which is really a fundamental right, has become kind of dangerous and a really tough strategy to pull off. And then also we're going to look at some key case studies specifically in the state of Indiana, stuff that Jack and his team have worked on specifically, and talk about how the verdicts on those trials ultimately give us some insight into what the future of jury trials look like, maybe not just in the state of Indiana, but even beyond that. So really excited to have everybody back. And Jack, it's great to see you again today. How are things going? I know you and the team have been working your tails off. What's life like?
Jeez, you weren't kidding about the whole roller coaster thing. Earlier today, time of recording, we had a jury trial that we were told was off, which is why we were able to schedule today's filming time, because it was the first opportunity in almost 6 weeks for us to be able to sit down and do this. Then we were told that the jury was on. Then we were told the jury was off. Then we were told the jury was on again. And then finally, after both myself and my counterpart of the prosecutor's office explained to the judge, this is why this continuance needs to be granted based off of newly discovered evidence, it's finally off again. So it's been quite the roller coaster of a week, and it's only Monday. And it's just been nonstop since then. It's...
I know you guys are always buckled in.
They say there's no rest for the wicked. I can't say anything about that, but I can never tell you their attorneys are exhausted as all get out.
I hear that. Well, look, we're revisiting this greater concept of jury trials. It's what you guys eat, sleep, and breathe over there at Razumich Associates. But the kind of first core theme that we wanted to address today was how this seemingly fundamental right that we all have the right to a fair trial, how this right has become dangerous, sticky, tricky. I mean, use your adjective, but over the course of history, the greater landscape of trials has shifted drastically. So why don't we rewind the tape for a moment? Why don't we shed a little light for our audience on maybe a brief history, if you will, of the trials, and then we'll get into some of the big advancements and changes and things to be on the lookout for. But set the scene, if you will, Jack.
Sure. Very briefly, because I'm 90% positive we've talked about this on the channel before, because you are correct. We are trial attorneys. We are constantly in trial. So much trials. And this is something that we know very, very deeply inside and outside. But not to bore repeat listeners, for the new ones, hi, thank you for joining us. The history of the jury trial dates back to the late Middle Ages and the concept of the Magna Carta in England, and that's where we get the concept of a jury of our peers from, because the peers are basically the people who were exactly like you. They were other noblemen who were judging noblemen. Later, when the right of jury trial got extended to all freemen, as it was referred to, they still kind of got the concept of they went out and they grabbed people who knew you. It was basically kind of a character evidence-driven thing. You know, if John Smith from down the street is accused of stealing a horse, you get people who know John Smith, and you get people who know the guy who's accusing John Smith, and they decide, like, well, this does sound like John Smith. He's probably guilty of it. As the 16th and 17th centuries kind of moved into more formalized professional style settings with regards to the evolution of attorneys, the trials evolved along with them as well. And the concept was that you had independent jurors who didn't know anyone who was associated with the case. That was the idea of an impartial jury. And that, of course, got carried over in the New World with the 13 colonies and later the United States of America. Historically, juries were fairly common. If you were accused of a felony offense, I'm not saying that plea agreements didn't exist, but if you were accused of a felony offense, you typically went to a trial, and that trial was to a jury. And some of those juries were crazy long. I think that we talked about the Wineville chicken coop case, I think, on one of our earlier episodes. And that trial itself, that jury trial, took something like 37 days to get done. Just a long, drawn-out process on that. But eventually, as society continued to move forward, I won't necessarily say progress because I've got my own biases on the subject that we're talking about. But as society kind of continued forward and different changes in technology and different changes in policing, you started to see a change with how people who were arrested and accused of a criminal offense interacted with the legal system. And that really became the rise of the professional plea agreement and the decline of jury trials. I think that statistically speaking, the American Bar Association has determined that something like 96% plus of all cases nationwide that are charged in a criminal case never see a jury. They never, they don't proceed to trial. They get pled out in some fashion. And as a result, jury trials are increasingly rare. We're kind of a dying breed at this office because we actually do still try jury trials. And that's not something you see as commonly anymore.
Yeah, and then as we've seen the plea agreements stacking up and watching jury trials kind of fade away, almost being, of course, so many of us, myself included, I love a good courtroom drama, any sort of good TV surrounding the evidence that comes to play, a great prosecutor or defender, standing up and being able to give their due diligence to their client. It's always fun television, but gosh, is that fading so far from reality these days. And with all those plea agreements, we've seen, the rise of mass incarceration and RICO coming into play. So many of these things over the course of time. Let's shed a little light on this concept. I mean, do you, Jack, feel like it was the rise in the plea agreements was a direct correlation towards what we saw to be this mass level of incarceration coming in with from the 70s and kind of onward up until modern history, if you will?
I do think that, and if you trace the history of how we have approached law enforcement, there is a really sharp spike in the 1970s, and you kind of hit it on the head with regards to what is the mass incarceration problem we have in the United States. I'm not the first person to point this out. I probably won't be the last, but the United States, on a per capita basis, incarcerates more of its citizens than any other nation in the world. We incarcerate more people than China, Iran, North Korea, places that we consider to not be particularly free and open societies. We are proportionally incarcerating more of our population than they are. And I want to be very clear, per capita doesn't mean raw numbers. I think that I think like maybe the total volume of people incarcerated in China is more, but they also have more people. Our percentage is higher in the United States, and that really started in the 1970s. And there were two major things that really kicked that off, in my opinion. The first was the so-called war on drugs. When Richard Nixon was president, he declared drugs to be public enemy number one. It was a major crisis to order and health and whatever else popped into his mind that day. And suddenly drugs were the big thing. And in addition to the war on drugs, the government's attention to organized crime, specifically the five families in New York City, what we classically consider to be the mafia, they came up with a new tool to go after organized crime, and it was referred to as the RICO Act, which is Racketeering Influence Corrupt Organizations Act. It is a sweeping federal statute that makes it a lot easier to argue conspiracy to commit crimes. It allowed a little bit more of an easy way of connecting small unconnected events up to one of the big bosses to try to get people to flip on them or incarcerate them. And the two went hand in hand because there was a lot of drug dealing going on in the 1970s and 1980s. And depending on who you feel like listening to, the mob was either very involved in that or the mob wanted to stay out of it. But there were street people who were breaking the rules and dealing it, and they would get caught up in these things. And what you would see is these incredibly long sentences that were attached to these incidents. And as a result, it made it a lot easier for prosecutors to go to defendants and say, here are your options. You can proceed to trial and you can risk, 50, 60, 100 years, or you can take this plea agreement, which requires you to flip someone further up the chain of command on you, and you'll only get a prison for 5 to 10 years. And that was a huge thing. And if you want an in-depth view of that life, there's another YouTuber out by the name of Michael Franzese. He's not affiliated with the channel. I'm not getting anything by plugging his channel. He is a former captain in the Colombo crime family in the 70s and 80s. And he talks extensively about how RICO really did break the mob with regards to these longer sentences. And a lot of it was connected to the drug traffic. And Michael points out all the time that at least in his family, they were not allowed to deal with drugs, but it didn't mean that street people weren't still doing it. It wasn't catching people further up. So you've got this big change in the 1970s and 1980s where these longer sentences are becoming the norm. Drug crimes are giving police all sorts of new authority, all sorts of new tools. Prosecutors are basically able to threaten effectively life sentences without actually charging a sentence that would, without charging a crime that would require a life sentence. And it made it a lot easier. And that trend continues to today. I remember during the, both the 2016 and the 2020 U.S. presidential elections, there was a lot of discussion with regards to the crime bill of 1994 because Hillary Clinton supposedly was referring to certain types of criminals as super predators, and Joe Biden helped write the legislation, and part of that legislation just had ridiculously heavy-handed drug sentences. Like right now, in federal courts, if you have one proven prior drug conviction that incarcerated you or could have incarcerated you for more than 365 days, that is a mandatory minimum 25-year prison term in federal courts. And if they can prove that you have 2 unconnected felony drug convictions, that's a life sentence. And it's not that hard to get a felony drug conviction. And we'll talk about that when we get to the case studies.
Sure.
Well, let me rephrase it. It's not hard to get a drug conviction if you're engaged in that life. Let me put it that way. I'm sure that all of our listeners... I think
that's an important asterisk there.
I'm sure that all of our listeners are law-abiding citizens who none of this stuff would ever happen to, and they don't have to worry about it. So, you can just tune out on the rest of my lecture for the end of it.
Exactly. Well, you're alluding to something interesting here, and it's this idea of charge stacking. So we saw the RICO bringing in these massive sentences that were so scary when you're staring down the barrel of them. And then so naturally you're going to plead down to something smaller because you couldn't fathom having to spend that much time in federal prison. But then we move towards this idea of charge stacking where we can just start throwing everything in the kitchen sink at you so that once again, all these charges jump off the page and now you're more susceptible to wanting to take a plea. So Jack, talk us through kind of during all of the changes here with RICO and then charge stacking entering the mix, how the role of the prosecutor has really changed as well. It feels like it's even more offense, if you will, than they never had to play way back in the day. But What's your 2 cents on kind of the evolution of that role of the prosecutor during all of this time?
I continue to have mixed feelings about it. There are still prosecutors that I'm on extremely good terms with. The very friendly terms.
Sure.
They're guys that I went to. They're folks that I went to school with. They're folks that went through the trenches with me. The shift that we're seeing right now is definitely more of an adversarial system than I've ever seen previously, and it's not that it wasn't ever adversarial. I mean, they've got. People seem to think sometimes that as private attorneys, we're just so connected that we can pick up the telephone, make some calls, and make stuff go away. It's never been like that. But it wasn't pounding your head against the wall difficult. What we're seeing right now is cases that at one point in time probably would have been taken care of with a blanket charge. So there's concepts in the law about a continuous course of criminal conduct versus each incident represents its own individual act that represents criminal liability. So, for example, the way charge stacking has typically worked is you charge the highest level offense that is possible. Then you charge any lower level offenses that look like they might be applicable to it as well. A good example would be burglary, for example. Burglary, it's defined under Indiana law as knowingly or intentionally breaking or entering the dwelling of another with the intent of committing a felony or a theft therein. So boom, there's your level 4 felony offense. Then under that, you'll see prosecutors sometimes charge residential entry, which is a level 6 felony. It's a much lower charge. And that just involves that you knowingly or intentionally break or enter into the dwelling of another. There's no concept of a felony or theft there, but you're still basically saying you broke into this person's house. Then if you commit any minor acts of vandalism in there, they might throw a criminal mischief charge in there also, just to basically say, here's a completely separate offense. Now, prior to the 1970s in the mass incarcetorial state, they would have just gone with burglary. They would have just stopped right there because that encompasses everything that the state is alleging happened. The state shouldn't be charging things that they don't think that they can prove. Adding the extra charges underneath them does two things. The first is it typically significantly increases the bond. Most county bond schedules are based off of cumulative charges. So if you've got a level 4 felony and a level 5 felony and a level 6 felony and a misdemeanor, a lot of these county bond schedules do basically say add them all up and there's your bond. So it'll increase the amount that the person has to pay. The amount that a person has to pay to get released from jail. So that's role number one with the prosecutors. They're just basically striking it. The other thing it does too is it does create that coercive effect of causing people to think like, my God, I don't want to go to prison for 30 years. They're giving me this lower level plea agreement. I'm going to go ahead and take this because that way I at least get a chance to go home and see my family at some point in time. And that has the impact of really chilling the concept of going to jury trial because it does become that big gamble at that point in time. You are dealing with a situation of and I've had this happen in my cases. It's not one of them that we're going to talk about today, but I have had situations where we have a really good, in my opinion, defense to a burglary. And the prosecution comes back around and says, look, why don't we plead this out on this lower level residential entry? Your guy goes home. He's a convicted felon, but you have the ability to expunge that later. You have the ability to modify the sentence later to have the felony taken off, and he's guaranteed to not go to prison. Versus if you go to trial on this burglary charge, and it goes wrong, like you might go to prison, and you're going to be a serious violent felon, and that's a difficult thing for people to really weigh, and that's a hard decision to make. And different counties seem to treat this differently. There's one county that I know of here locally where I've got a couple cases where they take the position that if they charge it, you have to plead to it, and they'll negotiate with you about the amount of time. But let's take the concept before, where you've got burglary, you've got residential entry, you've got criminal mischief. If this particular county charges all three of those offenses, any plea agreement you sign will be to plead guilty to all three of those offenses. They'll negotiate the time, the concurrency, what have you, but you got to plead all of it. And that has also changed, I think, the role of the prosecutor, is because the prosecutor's office is a political office in one way or another. Even if the actual line deputies are not politicians themselves, they answer to politicians. Right now, time of recording, Marion County, where we are located, we are in the middle of a prosecutor's election. Our county prosecutor's up for re-election right now. And I'm not going to say that is trickling down to some of the marching orders that the line deputies are getting. But there definitely does seem to be a little bit more of a situation of, are you with us or are you really with them type of thing? And it does feel like that, as we have adopted these attitudes with regards to law enforcement and with regards to incarceration and with regards to how people interact with the legal system, it does feel a little bit more like we are creating a very us versus them atmosphere. And it's a problem. Now,
Sure.
Fortunately, at least as far as the charge stacking is concerned, there are really only three places where this happens, and this will segue us nicely into the next section on this. But there are only three places where these really happen, and they are with sexual offenses, homicide-related offenses, and drug offenses. Most of the other offenses where they could charge stack, they don't. Fun fact, under Indiana law, it theoretically would be possible to charge someone who went into a Walmart to steal something. It's your standard shoplifting thing. You could charge that person with burglary. Legally, under Indiana's law, they went into a dwelling, dwelling would be for the level 4 felony, like a business burglary would be a level 5 felony. But they went into a business with the intention of committing a theft in there. That's burglary. The prosecutor's office could legally charge a shoplifter with burglary and then let it plead down to shoplifting. Now, fortunately, we have not hit that level of acrimony. But that's an example of charge stacking that you typically don't see. Same thing with like normal battery offenses. Theoretically, every time someone punches you, that is a separate criminal incident. But batteries, typically, they will allow to be classified under that continuous criminal action theory, as opposed to just the general charge stacking. Because you could theoretically punch someone 5 times and face 5 different battery charges. That would be perfectly legal. It's also stupid and aggravating, and I'm glad to say that we don't do that very often. But yeah, drug offenses, sexual assaults, and homicides. The occasional financial crime as well, but those are not as common in my line. But that's kind of what you're looking at with that.
Yeah, I mean, you painted a very interesting picture there, and it's one that seems to be a popular one, where this or that. Prosecutor shows you guys the opportunity to take a plea agreement, and you've got to make the call whether you feel like you got a great defense or not. Do we want to flip the coin? And I don't even know if it's a coin flip anymore. We're talking about odds that might be trickier than the 50-50 you would hope for in a coin flip. So that leads today's conversation now into the case studies, which, Jack, obviously we know from the comments and everybody that tunes into this show, that seems to be a fun part of it, is revisiting older cases, taking the lessons learned, applying them to the conversations that we have. So today we're looking at 2 different cases in particular. The first one being of Patrick Thompson, who had, and I believe it was 5 different rape charges for the same act. So that goes back to that, the charge stacking you mentioned specifically for sexual offenses. Let's get into this case study. Talk me through the X's and O's, if you will, and what some of the lessons learned that come from this.
So Patrick Thompson was one of the cases that I worked on a couple years back, and he is a great example of how charge stacking really has a psychological impact on the jury, the defendant, the bond structure, all the stuff that goes into it on that. So just very briefly, what happened with Patrick's case, the allegations in his case are that he sexually assaulted a teenage high school student that was a friend of his son's that was over for a New Year's party. Everybody got drunk. Patrick sexually assaulted her. The son walked in on it. They escaped, called the police. Everything kind of went from there. Before charge stacking, what normally would have happened with this would have been there would have been one count of rape, which is a level 3 felony offense. One count of sexual misconduct with a minor, because that is technically a distinct and separate offense from rape. You can have an inappropriate sexual relationship with a minor, but not rise to the level of rape. And you can, of course, have a rape charge with an adult. That's just how that works. And also counts of contributing to the delinquency of a minor for providing them with alcohol. What actually happened with Patrick's case is Patrick faced 5 different individual counts of rape for the same act. Now, keep in mind, by everyone's best estimate, this is the best estimate of the victim, this is the best estimate of the defendant, this is the best estimate of every timeline that we have on this. This attack took approximately 3 to 5 minutes. But each individual action that was taken during that rape was provided with its own separate charge. So there was an allegation of rape for vaginal penetration. There was a separate charge of rape for anal penetration. There was a charge of rape for basically putting his mouth on the left breast. There was another charge of rape for putting his mouth on her right breast. There was a charge of rape for putting his penis into her mouth. That's 5 separate charges for one continuous act. And that's what charge stacking looks like. Because what the state was able to do with that is they had his bond. His bond was set, I'd have to go back in my notes and look at it to be sure, but I believe that his bond was set in the area of around $35,000 cash only. That's a lot of money. The median annual income for a person living and working full time in Indiana, I think the most recent numbers that we had were from 2020. The median income in this state was something in the area of around $58,000 to $62,000. And for those of you who have not had to be in a math class for a very long time, median means the average. That means like half the people are making more than that, but half the people in the state are making less than that. And let me tell you something, the half that are above that, they're not committing a lot of crimes. Yeah, crime is kind of an opportunity thing that are done on the lower levels. So this bond is effectively, under the best of circumstances, a bond in the amount of $35,000 is... that's enough that's more than half a year's salary for a lot of people. And that has an impact on your ability to maintain your defense, to maintain any degree of normalcy. And it has a psychological impact on the jury too, because this one did go to trial. And part of the reason that this one went to trial is that the defendant was adamant that he did not remember anything that happened because of his intoxication levels. I will point out that voluntary intoxication is not a defense to pretty much anything in the state of Indiana. You can't get sauce to the gills, break the law, and say, I was drunk, I didn't know what was going on. There are circumstances where things like statements you make may become less reliable, but it's not going to be a situation where you are prevented from being brought up on criminal charges because you were drunk. He remembered everything after the case was done, which is a completely separate issue. So I guess the other corollary on that is don't lie to your attorney. Don't lie to your priest, don't lie to your accountant, don't lie to your attorney. I'll let you decide which order the importance is on that one. But because he had maintained the defense to me that he did not remember what happened, we were a little bit locked in. What I think happened is I do think that he admitted to having a sexual relationship with her. I do not believe that the accuser was credible, and we could spend an entire episode going into the reasons for that. It's not particularly important because at the end of the day, the jury found him guilty. But the jury hears that level of charge stacking also. And where one rape charge, you might be able to make an argument that that there's reasonable doubt. When you have them stacked 5 deep, followed by 5 identical counts of sexual misconduct with a minor, that creates a drumbeat of like, this guy is a shitbag. Like, my God, look how many times they've charged him with something. And that has the impact, I think, on some level of like, they wouldn't charge as many things if it wasn't that bad. And he went to trial and he was convicted and he got what, for all practical purposes, was a life sentence. He is currently serving a sentence of 70 years. 50 years of that is executed. 20 years of that is suspended or probation. By the time that he is released from prison, if he is able to be released from prison, he will be in his 70s. He would not be off of his sentence until he was almost 90, I think. And yeah, I'm not going to pass judgment. You can argue in the comment section if you want, if you think that's not enough time, or you think that's too much time, or you think that's not, that he should have been put to death right away. Those are personal opinions. My focus is on the law, because the law is going to affect all of us one way or another sooner or later. And this is what happens when you allow this type of charge stacking. It also backed the state in a corner. I'd have to go back through my notes and try to review what the best offer that was provided on this case was. But it was kind of very much one of those things where it was, I think that the best offer they put on the table is I think they were willing to let him plead out to 1 count of rape, which in Indiana has a 3 to 16-year sentence range. But it was very clear that the state's position on that was, look, if you don't want to take this plea agreement and we go to trial and you're convicted across the board, these are considered to be crimes of violence. They can run consecutive to each other, and we can just basically pile the sentence up and you die in prison. That's probably what's going to happen to the poor guy. It's one of those things of he wanted to exercise his right to trial, that he believed that he was not guilty of the crime of rape, that he believed that it was a consensual sexual encounter. Which is a defense. The difference between rape and regular sex is the concept of consent, but he believed that he was not guilty of rape. He believed it was a consensual sexual encounter. He went to trial. He did not successfully convince the jury that that there was reasonable doubt, and he paid the price for it.
One thing that's really important here, actually 2 things that are, I think, really important to note here, Jack. The first is we are not doing a full deep dive into the arguments made on both sides of the case here and assessing our own opinions. Like that, we would need another whole episode dedicated to Patrick Thompson's case in order to do that adequately. So that's the first important takeaway here before we move on to the next case study. But the other important takeaway is simply acknowledging the power that is of the charge stacking here. The power that is in the sway that it has on a jury specifically. When you're handed the plea deal versus a situation like Patrick Thompson is, where you're going to go up against a jury that's going to have this awful, what is already an awful story, but copy and pasted 5 times over to make you seem like the worst of the worst. That's an uphill battle. That is an uphill battle. And it goes back to that key pivotal decision that Patrick Thompson had earlier, where do I want to take the plea or do I want to exercise my right to a jury trial? And, you could say he chose wrong based on the outcome of the trial and his sentencing. But two really important key designations I wanted to make sure that we hit on before we rolled on to the next case study, which is another big one, Jack, that you and your team had worked on, and that's the case with Eli Burns. So let's pivot now. But again, this is another illustration of charge stacking here. But walk us through Eli's case and why we wanted to bring it up here really today.
So Eli's case, we just wrapped Eli's case up earlier this month, or it was either late last month or earlier this month, time of recording. And his is really the case that made me want to record this as a topic on this one. This is another sexual assault case. Eli was accused of a child molestation offense against his stepdaughter. Now, I can hear everyone already recoiling pretty viciously out in the comments and out in the viewer world. But here's what you need to know about this case. These are the things that you don't get when you look at just the headlines. The young lady that accused Eli made her first accusation against him when she was 9 years old and recanted it about 3 months later when she was being interviewed by DCS because she admitted that she was upset with Eli because he and her mom were arguing. So that's the first accusation that she makes. Recants it, says, I made it up. Second accusation comes a year later, very similar situation. This pattern continues for almost 3 years before the, I believe it was the fifth accusation that they finally decided to pick up and do something with. I can't tell you why they picked up that accusation but left the other ones by the side. But there are police reports on all of them because I reviewed every single one of those police reports. One of the police reports specifically had an officer saying, we're not doing anything with this because she has a previous false accusation in her history. But he gets charged with it. As the case is proceeding forward, the state moves to amend the charging information to add another count of child prostitution because they are alleging that Eli, along with this young lady's mother, were conspiring to sell her into prostitution. That's an accusation that she made that was against both her mom and Eli. So the state files additional charges on that. As this case is proceeding forward, things happen with it. The mother, the girl's mother, the mother who is accused of trying to help sell her child into child prostitution, is given a plea agreement by the state of Indiana that shields her from prison time, that gives her a low-level felony offense, suspended just to probation, and does not require her to register as a sex offender. This plea comes to the co-defendant approximately 90 days after these charges are filed. And in exchange for this sweetheart of a deal from the prosecutor's office, she has to testify against Eli. Talk about what a terrible child molesting bastard he is. And think about this for a second. If you want to talk about the power of the state, the power of the prosecutor to decide winners and losers, they have filed charges against a woman that supposedly is conspiring to sell her child into sex trafficking. And they are basically saying, if you testify for us against this other guy that we want more, we will not only not send you to prison, we're not going to make you register as a sex offender, and we'll allow for you to work towards reconciliation with having your daughter returned to you. So Eli's case comes up. The case proceeds for a long time. I think the case, I got involved at the very tail end of it. I want to say the case was working its way through the system for at least 2 years, maybe even closing on 3 years by the time I picked it up. If you added all of Eli's charges up between the charges that he was facing and the habitual offender enhancement, which is another cudgel that the state uses to basically say, look, if you don't plead guilty the way that we want you to, we'll file this habitual offender, and then that's an additional 6 to 20 years that's non-suspendable, that's mandatory consecutive to the rest of your sentence. Eli was looking, by my count, at a maximum of 116 years incarceration if he went to trial and lost. What the state came to him with is the state came to him with a 13-year plea agreement with 10 years ordered executed. And keep in mind, he'd already spent not quite, it was because again, the credit time, he had spent not quite 3 years in prison by the time this case came up. So they bring him a 13-year plea agreement, 10 years incarceration in the Indiana Department of Corrections. He's already got credit for 3 years on this. He has to register as a sex offender, but he also gets the chance to go home versus go to trial and risk 116 years. And think about this really, really hard, because his accuser has a history of false accusations. His accuser has legitimately said, I made this up because I was angry at him. The woman testifying against him, his ex-girlfriend who's going to be testifying against him, is being given a deal by the prosecutor that says, we don't really care that you were accused by your daughter of sex trafficking. We want you to testify against this guy more. That's not exactly the most reliable witness. That's someone who is an axe to grind and someone who has an incentive to be very cooperative with the state. This is the evidence that's against him. An unreliable accusation from an unreliable accuser who has a history of falsehoods, and a woman that the state dangled a life preserver in front of 90 days after she went to jail that she took. And I can't blame her for it. I don't feel bad for her. Someone had offered that to one of my clients. I tell him, like, flip that person so fast, don't look back. Because again, why would you put yourself in that position? But that's the evidence that's arrayed against him. Versus, you've already spent 3 years here. Your worst case scenario, you're spending 2.5 more, and then you get to go home. It's a no-brainer at that point in time. And he had the same decision. He had the same decision choice that Patrick had to make. It's, do I stand on my principles and say that I didn't do this crime, or do I risk having the jury hear 8 different counts of child molestation and think, my God, this guy's a terrible human being. He must have done this. They wanted to charge us 8 times on it. It just doesn't work. Like, there is, I don't care how strong you think you are. When those bars clang behind you and you're told you can't leave. People went insane 6 years ago because they couldn't leave their house to go to the grocery store. You still had cable TV, video games, the internet, family, friends, pets, everything like that. You don't have any of that stuff in prison. And I don't care who tells you that you do. You don't. And if you're told that you have an opportunity to escape that 6x8 cell, most people are going to take it. Most people might roll the dice if it's like, okay, I'm only looking at potentially 5 to 10 years, I'm not going to admit something I didn't do. When they see, when the amount of time that you're looking at has 3 digits in it, that calculation, like, those numbers don't mean anything anymore. Everything you've ever known is gone when you come out. People who went to prison in 2006 that are being released now, like, the iPhone didn't exist in 2006. I've got people that I've worked with who were in prison for so long, by the time they were released, they had no idea what social media was. Like, that just wasn't a thing. Like, the world doesn't exist anymore. Like, that's how much this time is. Mm-hmm. So yeah, he signed the plea agreement, and it was the right decision for him. We had a lot of long discussions about it. It came down to the wire. He was very back and forth, and I think at the end of the day, he wanted to be able to see his family again. And so he signed the plea agreement on that one. But
and when you're sitting with stories like Patrick Thompson's as well, Jack, I mean, it's, you've got Patrick Thompson, of course, who made the other decision. Let's fight this in trial, to go on and lose and not see the other side of the cell for 70 odd years, you mentioned, or until he's 70 something. Yeah, you sign that agreement when that's in front of you. But Jack, so I mean, the big massive takeaway is, obviously, don't put yourself in a position to commit a crime first and foremost. But the state's in the driver's seat here. I mean, the prosecution has all the power with regards to plea agreements, charge stacking. I mean, they're really in the driver's seat here. So our kind of third and final theme, if you will, is really, where do we go from here? What's your 2 cents on jury trials and the future that is jury trials? Because you said at the top of the show yourself, you and your team are a dying breed. Obviously, there's still a massive need for your services, and you guys kick butt at what you do. But what's your guys' outlook on the future of jury trials?
It's not great, to be perfectly honest. It's hard. The risk to reward ratio for proceeding to a jury trial versus not proceeding to a jury trial is very complicated. I want to start out by saying that the most important thing that you can do is anytime a state election comes up, not federal election, the federal government's going to do whatever it wants. It doesn't have an impact on your day in, day out life on a regular basis. Your state elections matter. Anytime someone runs on a platform that we're being soft on crime, or we need tougher sentences, or we need this, that, or the other, the police department needs tanks or something along those lines, I'm not going to tell you to vote against them out of hand, but do research that stuff a little bit more carefully, because what I can tell you after 20 years of doing this job is tougher penalties do not work. No one sits there and thinks to themselves, I could rob that convenience store, but I might get a minimum of 3 years in prison versus a couple $100 in my pocket. And that's assuming that no one gets shot or hurt in the process, which would make the penalties harder. I'm just not going to do it. No one thinks that. No one understands what these sentences are. No one thinks these things. Crime is something that is done on impulse. Like 99% of all crime is an impulse, poor impulse control. That guy has something I want, I'm going to take it. That person disrespected me, I'm going to make them pay for it. They've got me angry, I'm going to do something about it. 15 some years ago, I think, I went to speak to a full day's worth of classes. One of my friends was working as basically a guidance counselor is the easiest way of describing it, in one of the so-called troubled schools. And I spent the entire day talking to teenagers who had no idea how serious these penalties were. At the time that I was there, you could be charged with a felony offense in Indiana for stealing a candy bar. A 99-cent candy bar could be a felony offense. These kids had no idea about that. And it's not like adults know this stuff any better either. So the first thing that I would say that we do is we've got to stop electing people or supporting people who say that we're not tough enough on crime. We need more things. The second thing that we need to do is, and this is the scary part. This is the hard part for everyone. Remember what I said, that something in the area like 96% of all cases plead out, they don't go to trial. They have theorized that back up for a second. Sometimes my mind moves faster than my mouth. If 96% of cases are resolved without jury trial, that means that only about 4% of cases are going to trial. They have theorized that if 7% of cases went to trial, the court system would grind to a halt, because there's just not enough people to make all of this work. There's not enough time. There are not enough resources. And you have to tell people that for the betterment of everybody, you've got to start trying cases. And that's not to say that every single plea agreement that comes down the pike needs to be rejected. My own personal biases aside, I would say that 99% of all time, the police are doing their job properly. There are not very many people in my 2 decades of doing this that I would say are both morally and factually not guilty. The issue of moral guilt is something between you and your priest. The issue of legal guilt is between you and me. But in 2 decades, like, there haven't been that many, and I've represented well over 1,000 people at this point in time. It's kind of one of those things, like, you just kind of get the concept is like, okay, here's how this guy's feeding me in a line, this guy's not feeding me in a line. This guy legitimately has done nothing wrong, but the system is trying to crutch him. So innocent people do get sucked up in these things. Probably not many. I hope not many, but enough do that we need to care about this stuff. Mm-hmm. Because the only thing that separates people from being in the jury box versus sitting right next to me in the dock is the circumstances that surround him. I have never taken a single case to trial that involved a defendant that ever thought that they were going to be there. And yes, we can make the argument that, well, don't put yourself in that situation. Some of them didn't. Some of them absolutely did, but a lot of them didn't. A lot of them just kind of took a wrong turn or pissed off the wrong person or posted something somewhere where it shouldn't have been, and things went sideways for them. It happens. And if you make all of your decisions based off the concept that this is only going to affect those people, you really can't cry too much when you become one of those people. And that's the big thing that we're trying to avoid here. And the only way that we can do that is you can force reform. And reform is slow. Reform is either you elect the appropriate politicians who are going to be smart on crime, which is significantly different from tough on crime, or you just have to start doing more jury trials. You can either grind the system to a halt from the inside, or you can try to change it incrementally on the outside. Those are the options.
Jack, that's a really unique place to end. I think it's a good spot for people to kind of take that conversation to the dinner table tonight. Take it to the get together with your friends and sit and gauge people's thoughts. This is meant to be a very interesting conversation for progressive, helpful, intriguing dialogue out there. It's not meant to grind people's gears and start arguments. It's meant to examine the greater the landscape that is criminal defense and jury trials as a whole. And I think that's a really good place for us to end today. Jack, as we had mentioned, gosh, countless times, the one that's coming to my brain in this moment is when we did our episode on just the general duty to retreat and self-defense. I mean, you make what is it? There's a statistic out there. You make something like 100,000 or so decisions a day. It's something like that. What you want to eat, what you want to drink, what foot to step on the stairs as you go up. You make 1 million decisions a day, or 100,000, and it only takes one of those decisions in a split second of time to land yourself in the box near you, Jack. So for anybody out there that maybe made the wrong decision and does find themselves in that situation and is now faced with dealing with the prosecution of today with these charge stacking and plea agreements and whatnot, and they could use a fighter in their corner like you and your team, Jack, what is the best way somebody could reach out to you guys and just open up the conversation?
The best way always is by telephone, and the main switchboard number here at the office, as always, is 317-983-5333. Our phones are manned 24 hours a day, 7 days a week. That does not mean that my senior staff is working 24 hours a day, 7 days a week. We do have people answering the phones. Senior staff does get nights and weekends off sometimes. I'm usually working, but that's the curse of having your name on the door. But yeah, give our office a call. If you or a loved one's been accused of a crime, talk to us. If you don't talk to us, talk to somebody. Like, don't just throw your hands up and say, to hell with it. I'm guilty. They got me. Or like, what is the fight gonna? What's fighting gonna do? No one's gonna believe me anyway. That's how they win. And I'm not saying that every single case that walks through our door goes to trial. The vast majority of our cases plead out as well. We typically, in my opinion, are able to get more favorable terms and resolutions than they might have had if they didn't have us, because we do put that work into it, because we do that heavy lifting. But we'll also try your case. If it comes down to the situation of you absolutely do not want what the state is selling, we will absolutely back your play, and we will 100% take your case to trial if we have to. And we'll make sure that you get the best damn defense that you can possibly get. And that's a promise we make to everybody.
I love it. Jack, as always, I appreciate your time, of course, your team's due diligence and their time as they put together material for us to jump into each and every time we get together. Look, folks, we're looking forward to being back for another episode here coming up soon, so be sure to keep an eye on all the Razumich Associates social media channels and whatnot. Of course, make sure to subscribe to the show on whichever platform that you checked us out on today so that you don't miss out on future episodes of Closing Arguments, where we dive into case studies, criminal legal concepts, pressing issues that are facing the greater state of Indiana or even the country at large. A lot of great stuff on the horizon for you, and we'd love for you to be a part of it. So make sure to hit that subscribe button. But Jack, as always, I appreciate you and your time, and we'll see you back here on the next one, man.
Absolutely.
Alrighty, folks, take it easy. Have a great, wonderful day, and we appreciate everybody stopping by and being with us today on Closing Arguments.